Hello and welcome to the final topic for Week 7 LLB203 Constitutional Law. So far this week we've been looking at the taxation power as well as the grants power in Section 96 of the Constitution. This seventh and final podcast this week is going to look at the spending power and set the scene for you to read the important High Court decision in Williams and the Commonwealth No. 2. By now you should hopefully have watched or listened to the opening song as well as the welcome podcast and possibly also read the textbook. This podcast will provide an overview of the power to spend. Now, it had historically been thought that the power to spend the Constitution was derived from Section 81 of the Constitution. Section 81 provides that all revenues or monies raised or received by the executive government of the Commonwealth shall form one consolidated revenue fund, to be appropriated for the purposes of the Commonwealth in the manner and subject to the charges and liabilities imposed by this Constitution. Now, since Federation, there have been two main views as to the proper interpretation of this provision. There was the narrow view, which was set down in the pharmaceutical benefits case, which provided that an appropriation for only purposes for which the Commonwealth may otherwise legislate under this Constitution was permissible. The wider view, however, which was set out in the AAP case, provided for an appropriation for any purposes the Commonwealth itself determines. And indeed it was that wide view that for many decades had prevailed. However, the controversy surrounding the proper interpretation of Section 81 began to be reconsidered by the High Court, first in the decision of Pape and the Commissioner of Taxation, and then in the two Williams and the Commonwealth cases, which we will get to in a moment. Let's first focus now on what was going on in Pape and the Commissioner of Taxation. Pape considered the validity of the Tax Bonus for Working Australians Act, which was a response to the global financial crisis. This was the stimulus money that the various taxpayers in Australia received to try and stimulate the economy to minimise the impact of the global financial crisis on Australia. Now, Pape challenged the validity of the Tax Bonus Act and the payment that had been made to him under that Act. Now, the Commonwealth submitted that the Act was within power by virtue of any or all of the following. First of all, the first argument was that there was a substantive legislative power founded in Section 81 of the Constitution to authorise spending of appropriated funds combined with the incidental power in Section 5139. The second ground was that it was supported by the executive power in Section 61, read together with the incidental power and Sections 81 and 83. There was also an argument relating to the implied nationhood power, the trade and commerce power, the taxation power, as well as the external affairs power. Now, ultimately, the Tax Bonus Act was held to be constitutional. Significantly, the court unanimously rejected ground A, that is, denying a substantive legislative power founded in Section 81 of the Constitution to authorise the spending of appropriated funds. A majority instead upheld the Act on the basis of ground B, the executive power together with the incidental power and Sections 81 and 83. That majority was made up of Chief Justice French together with Justices Gamow, Crennan and Bell. Justices Hayden, Hayne and Kiefel dissented. Hayne and Kiefel held that the Act was invalid but could be read down to fall within the taxation power, that was ground E, whereas Justice Hayden held that the Act was invalid in its entirety. Now, there were two main issues in Pape and Commissioner of Taxation that are important for us to consider. The first, does the Commonwealth have a spending or appropriation power under Section 81 and 83? And then what is the scope of the executive power to spend? So this first question, as I said, was rejected by the High Court. The majority, or indeed the whole court, held that Section 81 does not provide a substantive spending or appropriation power. Rather, Section 81 regulates the use of money received by the Commonwealth and provides for the appropriation of that money. It is not a substantive power to spend. See, for example, Chief Justice French at paragraph 81, Justices Gummow, Crennan and Bell at 178, Justices Hayne and Kiefel at 289, and Justice Hayden at paragraph 601. The court took the view that an appropriation merely permits the executive to spend. There had to be some other source of power that allowed that spending. So the substantive power to spend Commonwealth money, which involves an exercise of the executive power of the Commonwealth, will need to be found elsewhere, either in legislation or elsewhere in the Constitution, including the executive power, which is why the scope of the executive power to spend becomes very important. And in particular, the court identified in Pape that the scope of the executive power to spend covers first of all matters within the legislative power of the Commonwealth, spending related to the role and position of the Commonwealth as a national government, including spending to deal with national crises, and possibly, and this is just possibly, all spending supported by an appropriation, provided it does not impermissibly interfere with the executive government of the states. So Pape redefined what was the scope of the Commonwealth's power to spend, and this was once again at issue in the case of Williams and the Commonwealth Number 1, which was handed down by the High Court in 2012. So what was going on in Williams and the Commonwealth? In Williams and the Commonwealth, the Scripture Union of Queensland, which was a public company, entered into a funding agreement with the Commonwealth to provide certain chaplaincy services at the Darling Heights State School in Queensland in accordance with certain guidelines. Those services included assisting the school and community in supporting the spiritual well-being of students and being approachable by all students, staff and members of the school community of all religious affiliations. The funding agreement was entered into pursuant to the Commonwealth's National School Chaplaincy Program. This funding was not provided under legislation. It was provided under a series of funding arrangements administered by the Commonwealth, of which the funding agreement was one example. Now, Ronald Williams, who was the father of 4 children who attended the school, challenged the validity of the National School Chaplaincy Program. In 2010, he commenced proceedings in the original jurisdiction of the High Court, challenging the Commonwealth's authority to enter into the funding agreement with the Scripture Union of Queensland to draw money from the Consolidated Revenue Fund for those relevant years and to pay the appropriated monies to the Scripture Union of Queensland pursuant to the funding agreement. Now, the High Court held by majority that the funding agreement and the payments made to the Scripture Union of Queensland under that agreement were invalid because they were beyond the executive power of the Commonwealth. There was no legislation here, and in the absence of legislation authorising the Commonwealth to enter into the funding agreement, the Commonwealth parties relied upon the executive power granted by Section 61 of the Constitution. Now, relevantly, Section 61 provides that the executive power of the Commonwealth extends to the execution and maintenance of this Constitution and of the laws of the Commonwealth. A majority of the High Court held that in the absence of statutory authority, Section 61 did not empower the Commonwealth to enter into the funding agreement or to make the challenged payments. In particular, a majority of the court held that the Commonwealth's executive power does not include a power to do what the Commonwealth Parliament could authorise the executive to do, such as entering into agreements or contracts, whether or not the Parliament had actually enacted the legislation. A majority also held that Section 44 of the Financial Management and Accountability Act did not provide the Commonwealth with the necessary statutory authorisation to enter into the funding agreement or to make payments to the Scripture Union of Queensland under that agreement. So again, a very significant decision on the scope of the executive's power to spend. Now, following the High Court's decision in Williams Number 1, the Parliament passed the Financial Framework Legislation Amendment Act, which gave legislative authority to the executive to make, vary or administer any arrangement by which public money is paid out by the Commonwealth and the grant of financial assistance to any person whatsoever. The Financial Framework Legislation Amendment Act amended the Financial Management and Accountability Act and the Financial Management and Accountability Regulations to provide legislative support not only for the making of agreements and payments of the kind which were in issue in Williams Number 1, but also for the making of other arrangements and agreements. Mr. Williams was still unhappy and once again challenged these laws and brought proceedings in the High Court against the Commonwealth, the relevant minister, and the Scripture Union of Queensland, challenging the validity of the relevant provisions of the Financial Management and Accountability Act and the Financial Management and Accountability Regulations that had been inserted by the Financial Framework Legislation Amendment Act. He challenged the validity of those provisions both generally and in their particular operation with respect to the payment of money by the Commonwealth to the Scripture Union of Queensland under the funding agreement. And so that then is the background to Williams and the Commonwealth number 2, which is a very important case and one that you will need to read to be able to understand the scope of the Commonwealth's power to spend. So now that you have had this brief podcast that provides an introduction to some of this material relating to the spending power, you should now go away and read Williams and the Commonwealth number 2 before contributing to the discussion board, whereby you can try and identify, following the High Court's reasoning, in particular Williams number 2, but building upon Pateman Williams number 1, what is the scope of the Commonwealth's power to spend money under the Constitution? Please contribute to that on the discussion board. It will also be considered in a tutorial in future weeks. As I said, this is one of the most important decisions the High Court has handed down in the last decade, and as such, I really do encourage you to take the time to read and understand this decision for yourself. That then brings us to the end of the Week 7 material relating to taxation, grants to states, and also the spending power. Next week, we will begin to look at some of the prohibitions or restrictions that have been placed on Commonwealth legislative power. Thank you.